way the form I have given to that poem become an intellectual property. So a property which is ideated, the idea comes value. The inventor or the creator of the idea and converted into certain form, it is things coming up. So there LERI and so many things. Even the logo LERI and so many things. Even the logo is right and the moral right regarding that property. So what is intellectual property right? Now we talked about intellectual property, we talked about intellectual property. Now what is intellectual property right? In simple sense, any property or any creative idea which takes a certain form, which is ready to be sold, owned, leased, or given as a license or a property to somebody else. It is generated from one's intellect, then it comes under the frame of IPR, intellectual property right. So now that when we talk about right, then the legal aspects comes into picture. It become a law. So something in the form of legal instrument to save my intellectual property will be called as intellectual property right. So the question arises, why there is a need for intellectual property right? We were the authors, the poets, even the inventors were doing so many things. So what happened that that intellectual property right was given so much of importance. So it was because I think that particular picture is coming after a few slides. If I am coming with something and somebody told me that look, I have created something new, and he or she shows it to me, and I found oh my god, it is the same as it was of mine. So here lies the problem, that your creative product in the form of intellectual property can be taken away by somebody. It can be infringed, it can be taken away, it can be uh, the credit will not go to you but to the other person who was little bit more aware about, yes, that converted into certain property rights. And hence, to prevent the infringement by the competitors in some ways, should be known to us. Similarly, it also why there is a need for IPR or intellectual property right, because it gives us complete right. Once we got those IPR for our intellectual creation, we legally are liable for all those moral and creative products completely. Means nobody can commercially use it in any form without our permission. Similarly, nobody can take credit for its creation until and unless it is permitted by you. It improves country's innovation index. Dear friend, I have taken some screenshots. In my coming slide, you will come to know. Earlier in 2015, India was far behind in the this innovation index. What is innovation index? Any country which is doing something out of the box or creating something new will be getting a name in the list of the innovation index. Now the India earlier in 2015, it was far behind, around I think it was 68th in number. Then it slowly started coming up. It was just jumping from its earlier position, and now in 2023 innovation index, it is now placed at 40th position. From 68, 78, it came to 40th position, which is a big jump. Which is a big jump. What does this suggest? This suggests that the Indian people are very much getting aware of their intellectual property rights. It also helps in channelizing investment and research and development process, because you always, dear friends, doing something new, anybody will be investing money in that. Anybody will be investing money in that which is novel, which is innovative. And for that cause, you should be knowing about the that it should be properly channelized, and it will be properly channelized if you know about your rights. IPR, intellectual property rights. Similarly, it also facilitate give you certain facility. Suppose you want to earn some money out of your intellectual creation, automatically you can grant that license to somebody else for the development work, and you will be given royalty for that. So you will get monetary benefit for your creation and invention. So, as I already told you, I've taken this screenshot of the Global Innovation Index of 2023 ranking. You can see India is not figured in the first 15 also, but India got a jump by 8 places. After 2022, it got a jump by 8 places, and now India is at 40th place and amongst the middle income economy. We are India is a country which is in the middle income economy, and it has jumped so far. So how that jump happened, this guides. So from one of the internet site, how that jump happened, this guides. So from one of the internet site, it is talking about why in the government of India in 2016 framed new IPR policy. And from that policy, what was the objective behind that framing that policy? That government wanted to make people aware about the IPR, as well as government wanted to do more of investment in those innovative things which the Indians were doing. For example, I have taken one example of the cancer drug. If Swiss Pharma Company, what was the patent for that? 1 lakh rupees. But in the India, which is doing great in the generic drug field, it was selling the same drug in 8,800. So it was a big marginal difference. For the in case of the developed country like US, it is not a big problem. But in case of the country like South Africa, India, which are in the developing stage, automatically, although we are now jumping as a very, we are emerging as a super economy, but still India was always like helping the other country in developing. And this particular phenomena of India was really troubling US, because the US companies were selling the same drug in 1 lakh rupees, and the Indian countries were selling it at 8,800. So why I've taken this example, just wanted to tell you that IPR is so very important. We should know, we should know, create that awareness, know about IPR. Similarly, I've taken this statement of one of the minister from the sub-Saharan Africa country, where he said that if we are not providing the drugs because of all these IPR laws, we will be committing genocide. What is genocide? We will be committing killing of so many people who will not be getting the drugs at the affordable rate. So the reason behind taking all these examples is to convince you that how IPR can make a big difference, and how the India can make a big difference. That this is the statement of this minister, who has really said that if we are avoiding access to the affordable generic drug, then we will be, that will mean genocide for the South African country or the developing country. So now coming straight to the IPR, I've talked so much. I've just tried to convince you how IPR is very important, and from the different countries' perspective, it is having a different importance. Now, categories of IPR. So in general, I already told you intellectual property is a intangible, right? Now, no physical parameter will be defining it. Now, it encompasses 4 types of property. If we, I can broadly divide or two major category. It is the industrial property, and the other one will be the copyright and the related rights. So or in the core, if we will divide, it will be again patent, trademark, copyright, and trade secret. These are the four major things which which will be majorly coming under the ambit of IPR. Now you will talk me. You can ask me one question, right? Uh, what about geographical indicators, plant variety, even now integrated circuits, semiconductors? Now India is taking lead in semiconductors and all. So all these things are also taking much of the importance, or they people are getting inclined. So even the undisclosed information of some business houses or some undisclosed information is also now getting categorized in the category of IPR. So all these things are coming under the category of IPR. So all the basic point of contention. What is the basic point of contention? Why we should know about IPR? Any highly technological product, if we talk about any invention, innovation, research, design, testing, the most of the value of high technological product in the medicine, now you find so many people getting good in the medicine field, they are getting Nobel prizes. Now why they are getting Nobel prize? Because they are in the lot of innovation, research, design and testing is involved. Then what, why not we should also think about getting importance to our intellectual product. For example, when we talk about some films, music recording, books, computer software, and even online services, everything, dear friends, everything will be coming under the ambit of IPR. Only certain few conditions are there, and if it is innovative, novel, everything which is out of the box, which has never occurred, and which has certain commercial value, will be coming under the ambit of IPR. For example, when we talk about certain creation which you have taken in the form of a CD or some software, they are not just plastic or the metal or the paper. Even when we talk about book, they are more than that, because you have invested a lot of time thinking about the content, and you have created that content through your individual thought process, and hence all these things are coming under the ambit of this IPR. So I need to drive your focus towards this point: Universal Declaration of Human Right. Now, what is Universal Declaration of Human Right? In that Article 27 of Universal Declaration of Human Right, which was given by United Nations, it talks about the protection of the moral and the material interest. Why they have mentioned that moral and material interest? Because they wanted that whosoever is the creator of that intellectual thing should get that type of protection, and hence the start of this IPR rights also goes to that Universal Declaration of Human Right, where Article 27 has clearly defined that we should know about our material interest or whatever we have created. So, as I've already told, there is a lot of importance, hue and cry about IPR. You might be knowing that you have Neem got patented, Haldi got patented in in US, and then we fight it back. The CSIR lab fight it back, and they have taken the case that no, Neem, even that basmati rice, all these things belongs to our country. Although these were coming under the geographical indicators, but yes, we wanted to prove that point. So this type of tussle, I just wanted to tell you that this type of tussle will happen more, it will be more grave in the coming future, because now the people are getting aware that whatever I have created, all things, it belongs to me. The moral and the commercial right should hold with me. So why there is an increasing need of importance of intellectual property? Because we should know that we should protect our intellectual creation. Technology has created so much of awareness about IPR, because you might be all are knowing about so many things coming up. We were earlier talking about plagiarism, and now we are talking about chat GPT and blah blah blah. So many artificial intelligence coming into picture. So the technology has really increased our curiosity that yes, what will happen to our intellectual property and what so many things. Similarly, it is also why it is important, because we should know the importance of knowledge and brain power. Then simply the difference between we are in the knowledge economy. When we talk about the developed country and when we talk about the developing country, the major thing which is making the difference is the knowledge that we have. So that knowledge reigns supreme, and when knowledge reigns supreme, automatically we should know that if knowledge reigns supreme and we will be superpower, if we have more knowledge, then we should be also aware of our intellectual property right. I have they put in this particular point in hash. You just go through it. More than 50% of US export majorly depend upon the intellectual property protection, dear friends. What does this sound? US is the superpower right now in the world. How it is superpower? Because the people more are aware about the intellectual property protection, and hence their 50% income goes due to these exports. They have taken copyright, they have taken patent of everything. So whenever we are asking them to give us the product or manufacturing, that product needs the transfer of license or taking their permission, and there lies the major importance of IPR. If you hold that IPR, if you have created that, why not hold that intellectual property with us? And hence it become more of valuable. So nowadays, I will be failing in my duty in creating awareness about IPR if I am not talking about these conventions. So WIPO, you all are knowing about WIPO, World Intellectual Property Organization, and the two conventions which I majorly wanted to focus. Just remember the name: Paris Convention, which was about the industrial property protection, and the Berne Convention, which more talked about the creative or the literary and the artistic work. One in 1883 and another 1886. These were the majorly conventions. Conventions means there was a discussion at table about the protection of these rights, and these both treaties were implemented or taken up by WIPO, and WIPO is now majorly into this picture, that it is taking care of protection and prevention of all the intellectual property violation. So, in 1967, WIPO come up with the list of these are the intellectual property right, what are the things which will come under intellectual property right? And the performances. Now, performances of the artist, even the broadcast, podcast, all these will be coming under the copyright. Then inventions of all sort in all field, whether it is medicine, in the transportation, or any field, in the engineering, everything, even the scientific discovery. Then the trademark, as I already told you, service mark. For example, the service industry, for example, the tourism industry, they can have certain service mark. So that service mark, then the commercial names. So all these things fall in the ambit of IPR. Similarly, all the other right, which are the creation of human mind. Now, since most of the people who are attending this are the person who belong to academia, we should be very much aware that all the intellectual property, literary work, we are writing anything, if even the computer software program, it comes under the copyright. So all these things fall under the ambit of IPR. So intellectual property, all these fall and over under the ambit of IPR. So intellectual property, I will skip this. Two major area. One is the copyrighted right, and another one is the industrial property right. So in under industrial property, again there is a two major division. One is the distinctive sign. So it will be coming under the trademark and geographical indications, and another one is the industrial design or the trade secrets. So even the under this patents are also coming. Okay. So what is the need for IPR? I have already taken that. It encourages innovation, economic growth, because I have to directly come to the patents. So that's why I'm just switching over. The basic thing is, if we are getting protection, if I know nobody can take my rights from me, and there is a legal instrument to save it, automatically I will be encouraged to create more. And that is the objective behind IPR. My rights are protected. If I create something new, the rights rest with me. And if the right rests with me, automatically I will have that safety and security and that assurance that my rights will not be taken away by anybody else. And hence the need for IPR. Now coming to India and IPR, then we are also the member of a World Trade Organization, and we have signed one agreement which is called the TRIPS agreement. You should know about, when you talk about intellectual property, you should know about TRIPS, trade related aspects of intellectual property agreement. So India is also a member of World WIPO. So around 187 countries right now, I think 189, sorry, 189 countries are a member of WIPO. So all those who are a member of WIPO have signed the TRIPS agreement, and they have to abide with the rules and regulations for the follow-up of the IPR, even in their geographical boundaries, means every country specific. So India being the member, it is administrating all the rules and regulations which are mentioned in these TRIPS treaty. So few things I just wanted, I will skip this because it is little bit of detailing of that, but you just take care of this Marrakesh treaty. When you talk about Marrakesh treaty, this treaty was the latest into making major amendment in the Copyright Act. And the major amendment made was that uh, visually challenged people should get something, some relief from these protection right. Because dear friends, I would like to tell you, when I will be talking about copyright or these rights are called as negative rights. When we talk about IPR, a particular faction of the world feel these rights are negative rights. Why they feel like it is negative right? Because that negative word has been added, because it is controlling the spread of that particular innovation in the world. But I feel, if that control is not there, what will happen? Anybody who is not at all the creator of the work will be using it freely, and then that will really discourage the person to create more. And hence this Marrakesh treaty has taken care of the visually challenged people, and it said that certain relief should be given to the people. And even the India being the follower of the TRIPS agreement, and the Marrakesh treaty is a part of it, India has also implemented certain major amendment in its Copyright Act, because the visually challenged people need more of the intellectual thing from the literary part. So, as I already told you, a national IPR policy was framed in 2016 under the guidance of our Prime Minister, present Prime Minister, also Modi ji, and he talked about the seven things. The motto or the slogan of this national IPR policy was Creative India and Innovative India. So how the India will be creative and innovative? When the first major point was there should be creation about awareness about IPR, and hence the government is taking lot of efforts in creating awareness about IPR. And you might be knowing, in every college, as your college is also taking this IP importance of IPR, awareness of IPR is very needed. Then we want to increase our innovation index from 40, we want to go much ahead. We want to be in top 10. How we will go that? If we will generate more of IPR. Similarly, the legal and the legislative framework should be known to us. Why? Because in coming my slides, when we will be talking exclusively about patent and copyright, we will know about it. We should also know about the commercialization of IPR. We should know how the IPR is enforced, and we should also
एक्सेल
think about
जिसमें
how the
स्क्रीनशॉट लिया था
people
फिर उसको सेव
who
करो
are creating
या
awareness, who are generating
सीरियल
IPR are developed. So all these things are the
जैसे अभी
major things about the new IPR policy. I will skip this because, as I already told you, in the Global Innovation Index, after the framing of this policy, there was a major impact. In 2016, the policy was made, and in 2023, India has jumped from 68 to 40, which is a big jump, So this suggests that yes, the IPR policy is majorly instrumental in creating that awareness about IPR in the Indian amongst the Indian community. So the word of caution. But still the word of caution should be there. What is the word of caution? You might be knowing, I have mentioned this special 301 report. Now, UN being the superpower, UN holds 50% of the IPR rights, and its economy run because of those rights. They are every year releasing this report, which is a special 301 report, and it talks about the countries who are in the watch list. Now, what is the watch list? It is not for something good, it is for something negative, and which is that India is not falling in terms with the rules and regulation of the world in the enforcement of IPR. There is lot of majorly violation of IPR in India, and that is the word of caution. These developed country don't want developing country to really go for some commercial laws at their end, because as I already talked about the Novartis, which was selling the cancer drug in 1 lakh rupee, and India generated generic drug in just 8,800. But still, India is figuring into this special 301 priority watch list, where it talks about the violation of IPR, and it is rampant in India, what they have said. So, what is the way forward? How the India will progress then? Because India is figuring in the this watch list, then we have to create an environment of innovation. We have to create an environment of awareness. And we can see there are successful flagship program of government of India, like Make in India, Startup India, and these have really boosted. What is Make in India and Startup India? They are nothing but they are just giving a platform for that innovative, creative, new out of the box ideas coming out from the Indian mind. So that in this way, this is the way forward. So we India have started progressing in this, and in the coming year, I have no doubt that we will be majorly figuring into the top 15 countries in the coming years in the terms of innovations and in IPR filing. So, coming to types of intellectual property, now if we majorly classify it into like what are the different types of IPR, then it is patent, trademark, copyright, industrial design, geographical indication, trade secret, indicated circuit. These are the majorly things which are considering under, even now the plant variety, even the species of the bacteria are coming into IPR. So these are the major things. Now today in my session, I will be majorly dealing with patent and copyright. So coming directly to the patent now. If What is patent? Now, when we talk about patent, if I have created something which is a certain, for example, certain product, certain engineering product, certain innovative product, certain simple product, even a safety pin with a new design can be considered to be getting means that will be qualifying for getting a patent. Even a water bottle with a new design, unique design, can take a form of patent. Even the pen with different design can take a form of a patent. So what is patent? Patent is creation of some unique product or a process, or even a design can also be patented, but that should be in documentary form. The person who will be getting the patent will be called patentee, and that patent can be giving him the right, will be giving him the right to make more of that product, to use that product, to give that license of his product to other industry to manufacture it in a multiple way, and to sell an invention and preventing others from taking those rights, commercial rights, and the moral rights of that particular thing from him. So this is patent. So as I already told you, now if in general, if we talk about how many patent holders in India nowadays, there is a massive jump, my dear friends. 184 patents are held in India by CSR, CSIR lab. and it followed by Ranbaxy for the medicine. So mostly an IT company. So we will find that the medicine company, industrial research company, few CSR labs, and even now the patents is with various NIRF RAM institutions also, IITs and IIMs. These are also going for this. So many things. So the number of patents are continuously increasing, but the major still the player in this industry are the medicine, industrial, and the IT firms. So if in general, if I talk about what is patent, so if I am a layman, so as an inventor or as an assignee, I will be going to the government, I will be filing certain things, I will be putting my invention or my process or my product in a documentary form, and there is a specification how I will put it. I will be getting a consent from the government for 20 years that yes, now the right stays with you, and for that I will be paying certain fees and I will be getting that patent. Or I can legally sign an agreement and I can assign it to somebody. So it is like in general, if I say, so this diagram depicts how the patent in simple way it is. So what is the patent benefit of patent in India? If I talk about how the patent is benefiting India or to Indians, I would say, then it is like you own the invention for the given time. Now the invention, once you have patented, the invention rests with you. You can build a business because of that. For example, one of my robotic design for library bookshelf cleaning got a patent. Now, if I get some industrial people who is sponsoring my work, automatically they will be going into the manufacturing of that robotic device. And if they will go for that robotic device, automatically I will be getting royalty for that. I will be passing on that license to that particular business group who is so it helps to build a business. Okay, we can rent it, we can give the we can say that I can transfer the license to you, I can rent it, lease my license to you. It also give benefit that you can offer it for the sale, you can import your innovation in any country. For example, it is not confined to any boundary. If I am getting patent in India, it does not mean that I cannot claim for that. I can claim for that patent in some other country. I have to file separately because it is confined by the geographical boundaries. You can completely sell the patent to any other company. So this is the benefit of the patent. Now, in India, there are two acts of the patent: Patent Act 1970 and then the Patent Rule 2003. So majorly changes have been continuously occurring. But for the simple thing which we should know is that the major patent, if I am getting, for example, I got patent for my design, so it will be for 20 years. But in India, it is 20 years. For some other country, it might be 15 years. For some other country, it can be 10 years. So it varies from country to country. So, but from my date of patent, all my rights get activated. From the date of the grant of patent, I am eligible for taking all the commercial value from my product or the process which I have designed. So, what is how a product? I said is even a safety pin can be patented. So, what are the unique characteristics which make a particular thing, product, or process patentable? So, it should be novel, very new. It is the newest. It is the newest. Then it should be unique. For example, if I am new, if I can generate the same thing in a new form, it does not make sense. It should be unique. It should have some certain unique capability over that product which was already existing. So that is very essential. It should be non-obvious. Non-obvious means if I am doing something which can be done by any other people, then it become obvious. It does not make sense. It should be non-obvious. It was done exclusively by me. No, by it cannot be done by anybody else. Then it become non-obvious. It should be industrially applicable. When we talk about patent, the industry patent connect is very direct connection. So anything should have some industrial value. applicability. It should be helpful to the society, and finally it should be feasible for general public. It should be useful for general public. So if these five criteria are filled, automatically the product which I have designed or the process which I have said will be eligible to take go for patent. I have just shown a life cycle of a patent. So first idea comes to my mind. Then I have generated a unique product which is very novel, which is non-obvious, which is very different, which has some industrial value. Then I have gone for filing of the application. Then I got a grant of patent. Then I am monetizing from the patent. I'm getting money for my patent, because obviously the commercial value should be there. And finally, using the profit on R&D, I can use that for research and development or further research on my product. So in this way, this life cycle goes on and on and on. And this on and on really is actually the way this complete IPR rights really give you the boost that you create more, you create more, you will be getting commercial rights, you will be getting moral rights for that. So the grant of a patent. Now, if I want to take a patent, the first and the foremost step is to file a patent. Now, there lies the trick. I have taken patent first, and I will be taking copyright afterwards. Filing patent is a little bit difficult, because it has various technical. It is a very technical draft. It is a very technical draft. So, who can file a patent application? Then the question also arises, where to file the patent application and how to file. So that who, where, and how are the questions which are really very tricky. And we should be very sure about those parameters which I have already discussed. If all these criteria are fulfilled, then only we should go for patent. Otherwise, sometimes we get a rejection, and that really give us a pinching effect. So we should be very clear that all the criteria are fulfilled and we are ready. Now there are so many patent attorneys which are helping us out. But if we are very much sure about the technical part, then we can also give it a try. But generally it happens that majority of the people go to the patent attorney, because it is a, as I told you, that filing a patent is a technical draft. So, where to file a patent application? So, in India, there is a IPO, which is online. Also, you can see Indian Patent Office. The patent office are located at four places: Delhi, Kolkata, Mumbai, and Chennai. And in so in this way, the you have to file the patent for your invention, and there are certain set of forms means there are around 10 forms, and you have to fill in those forms, and you have to submit it. Now the provision for online submission is also there in everywhere. So for that you have to file a patent application. How to file a patent application? You can go for online, you can go through offline in the patent office. But now, procedure for filing a patent. First of all, application for the grant of patent. Application has so many different things which we need to fill. Then, once those things are filled, then second thing is we have to give the complete specification. I have said in my second point, you can see there is a provisional oblique complete. Now, the meaning of that: suppose I am in the process of creating something, but I have a fear somebody will steal my idea, and somebody will start making on that. Then I am in trouble. To avoid that trouble, government has given that facility that you can go for provisional filing. You can go for provisional filing, and